Morning, Alex.
Good morning.
We'll do our usual chit chat for a couple of minutes. We'll let everyone join, shall we? As you can see, everyone on your screen, you've got some delightful pictures of Alex and I. We could play the QR game, which is the LinkedIn game. If you want to connect with us, hold your phone up to the screen and we can see at the end how many new connections we've got. Let's do some housekeeping then, shall we, Alex?
Good plan.
Good morning, everybody. Welcome. This is a webinar, second in our series of COVID and work, looking to the future. So last week, I did a session with David D'Souza from CIPD, looking at what a return to the workplace is going to be like, which went really, really well. Today is about immigration, and I'm joined by Alex Russell, who's an employment partner and immigration expert. I'd love to say that we're going to present today, but we're not going to present today. Alex is going to do the heavy lifting and all of the immigration stuff, and I'll hopefully chair it appropriately and ask some insightful questions, or no, as Alex told me, James, no inane questions. So that will be my challenge for today at the end, to ensure that I've not asked any inane questions.
I'm sure there'll be none. I'm sure there'll be none.
Thank you, Alex. And then the rest of the series is next week is looking at remote working within the UK, and that's on the 12th. Following that is remote working internationally, and that's on the 20th of May. And then we hope to bring you one which is about the disproportionate effect of COVID on the workplace in relation to women and others, and that's to follow. Okay, so. This webinar is being recorded. We'd love to hear from you. Please use the Q&A button. Alex is going to talk you through the agenda, and as we go through each section, I'll then intervene and say, right, have we got any particular questions on that bit? Hard stop at 10:45. I'll flag it now that there'll be a feedback as you leave the Zoom. I'd be grateful if you could give us some feedback. And I think there's probably nothing else I need to say. Alex, over to you.
Excellent. Great. Thanks very much, James. Well, good morning. Really good to be with you online the best way we can be at the moment. Yeah, so what are we going to be looking at? As James says, obviously the focus of today is on immigration and COVID, and I think that's is quite a broad topic, really. So I thought we'd look at these sort of three areas, and as James says, pick up questions along the way. Firstly, I thought we should probably have a bit of a look at a COVID roundup of various sort of issues that have risen recently, some of the concessions that apply around visas, some of the tricky areas that you're having to navigate as employers at the moment. So I'll spend a few minutes looking at that, have a pause, pick up any questions that you've got. So that's kind of quite practical, lots of hopefully useful information there. But then I wanted to sort of go into a bit more of a crystal ball gaze, looking to the future. So thinking about really where are we at the moment in global mobility terms? What are the key kind of drivers influencing the mobility agenda at the moment? In particular, how is COVID going to fit with that? And then looking ahead to think, well, what's the future immigration landscape going to be? You know, to what extent might COVID be impacting on that? What's the direction of travel that we've got? So kind of game of two halves, really, a little bit of an update and then a little bit of a crystal ball gaze and reflection. As James said, if you've got questions, please do raise them. I'm really happy to try and field them on whatever you want to raise. You put them in the Q&A. We'll go from there at various stages of this morning. Good, so let's get cracking, shall we, on the roundup of a few things. I know there's lots of tricky areas that you've all been having to navigate recently. Probably the big one is this issue of right to work document checks that you have to do on new joining staff. So as I'm sure many of you will know, there's been a concession in place since the 30th of March last year, whereby effectively document checks can be done remotely over a video screen. You don't have to have the hard copy document with you. You can have a copy, the person can be on screen, hold up their passport, whatever it is, and you do the check that way. And there was talk about having to then, within 8 weeks of that concession ending, having to do the full face-to-face hard copy check at that point in time. Well, we've had an update and some changes on this, a kind of mix of probably good and bad, I would say, and the changes are kicking in from the 17th of May. What's going to be happening The adjusted checks, as they're called, i.e. those video checks, the last day you can do those is the 16th of May. And then from the 17th of May onwards, we are into the usual right to work check regime, which we've always essentially known. I know that's caused quite a lot of consternation because that's not necessarily tying up particularly well with actually the way we're unlocking, what workplaces are doing, how we're working at the moment, even some of the government guidance on how we should be working. But that's the position that we are in. I mean, what are the options going to be from the 17th of May? I thought it was worth flagging those, because there are different ways in which checks can be done depending on the circumstances. Obviously, one way would be through the online checking portal. That's available for people who are EU settlement scheme holders, or those who've got biometric residence permit, those credit card style visas. Those online checks can be done, which makes it pretty straightforward for those people. Otherwise, you're into slightly less attractive ways of having to do it. You've got the face-to-face hard copy document check, or you can be doing the check with the hard copy documents in your hand and the employee on a screen. That's been in place for several years, but it's not particularly attractive because people have to send their hard copied passports, whatever it may be, to you, and people often aren't very comfortable doing that. It's a little bit cumbersome. Or you essentially take a bit of a risk assessed approach around, well, okay, are we prepared to employ without actually doing the official check that we need to do? You are left with risk exposure to a civil penalty, potentially £20,000 if it turned out the person didn't have the right to work in the UK. And obviously, if you're a sponsor, that's not really in keeping with what you should be doing in terms of robust approaches to preventing illegal working. But from time to time, some employers may take a bit of a view on that and a risk assessment depending on the circumstances. So some changes that are not great. One of the good changes is that there's going to be no requirement for retrospective face-to-face checks, so no requirement to have to go back over all those people that have started since the 30th of March last year, where you've done the remote check. You don't have to then do the hard copy face-to-face check, which had been mooted. The government's essentially recognised that's just putting too much work and bureaucracy on employers, which is obviously good news. One question I've had raised a few times in recent days is around, okay, where are we in terms of the date of the check versus the start date of employment? How does that work out? Can we do a adjusted check by screen before the 17th of May in respect of a start date of employment from the 17th of May onwards? And that wasn't really particularly clear in the guidance published by the government. I've recently seen an email from the Home Office that has been sent to some employers, which does confirm that you can do checks up to the 16th of May in the remote format, the adjusted check, even if employment is starting after that date from the 17th of May onwards. The wording in typical Home Office fashion points slightly in two directions. It's sort of saying you should still be having a robust approach, thinking about whether you can be doing face-to-face checks, particularly if they're starting after the 17th of May. I think it's a case really of taking a bit of a view on that. You should be okay using the adjusted distance check, but if you have got an opportunity to do a face-to-face check, you should do that. And indeed, if the start date is starting to get quite a long way in the future, there's probably more onus on having to do that, and obviously keeping good records as to why you have done the adjusted remote check rather than the face-to-face check. For example, how you're working at the moment, the government guidance, the person working from home, whatever those reasons may be. Another area that's also caused, I know, quite a lot of problems, including practical ones, is around just getting into the UK. If you've got a visa or are looking to get a visa, obviously COVID's created quite a lot of chaos, havoc, and also quite a fluid time of guidance, where the guidance has regularly been adjusted, changed, often at the last minute, putting people in quite a difficult situation. One area that's cropped up that I thought was worth touching on is the issue of red list countries and entry to the UK. So we probably all know there's a list of countries where if you've been through those countries in the past 10 days, then you can't enter in most cases the UK. You're just banned from doing so. That includes quite a lot of big countries that you might expect people to be coming from regularly, like India, Brazil, South Africa, Pakistan, the UAE, amongst others. And there's been a question around, well, there's an exception to that. You can enter the UK if you've been in a red list country, if you've got residence rights. And the question is, well, what does it mean to have residence rights? If you've got a visa or you've applied for a visa to come and work in the UK, does that count? The answer to that is yes, in most cases. If you are somebody who is coming into the UK on a work visa, so a skilled worker visa, or indeed the old style tier 2 visa, you've already got one, or you've applied for one to come into the UK, or a temporary work visa, or indeed you're studying, you have residence rights and come in, which is obviously good. But it does not apply, that exemption, to visitors. So somebody who is a visitor coming in on that short-term basis to do non-substantive activities, that the red list ban does apply. Those people do not have residence rights to come into the UK. And some of the travel arrangements are really quite fiddly around some of this, and also quite expensive. So if you are coming from a red list country, even if you've got residence rights, you've got to be taking various COVID tests, have a negative test 3 days before you come into the UK, buy a quarantine package that costs you £1,750 to stay in a government approved and monitored hotel. You've got to fill out a passenger locator form, all those sorts of things. So quite a lot of stuff to work through, not particularly sort of streamlined or user friendly. If you've not been through a red list country, so you're coming in with a visa from a country that's off that list, you still have to take certain steps like filling in a passenger locator form, taking a negative COVID test 3 days before you travel, still buying a package for quarantine, albeit much cheaper, and you've got to quarantine essentially in the place that you're coming to stay in the UK, friends, family, a hotel, wherever it is that you're renting or have got to live in the UK. There are some exemptions to all of this for certain roles. You may be reassured or not reassured to know that if you are a nurse coming into the UK to take up a position in the NHS, you don't have to do that, don't have to quarantine, even from a red list country, which is a little bit surprising. But there we go. There are lots of other roles that are covered in the same way. I mean, where does that leave us in practical terms? I think practical terms, key things on your radar are, one, the costs. So people coming from red list countries, there's in particular a big bill to get into the UK on top of the usual visa costs that come with that. And it might be that you will be asked to put your hand in your pocket and want to think about that for new joiners. There's also something to bear in mind around just communicating with new joiners and visa holders about what they have to do, making sure at the very least, I think, they're pointing in the direction of the government guidance. And also, I think, thirdly, thinking about just start dates, how that's going to work, filtering in this extra time. As we'll see in a moment, it's not quite as straightforward as it usually is to come into the UK. There can be more delays. You've then got the quarantine. I think all of that needs to be built into the recruitment timeline, just so that you've got the expectations right around when somebody can start employment. Sort of continuing on the same theme on visa applications and some of the other things to have on your radar. If you think about it, there's been an obvious problem, which is people who are in the UK very often have been unable to leave the UK due to the travel restrictions and the COVID issues that have been in play. And there's obviously been a question around, well, what happens if your visa is going to expire when you're in the UK? What do you do about that? Because normally if it expires and you're in the UK, that has a detrimental impact on your ability to apply successfully for visas in future. You're labelled as an overstayer. There is this regime in place called exceptional assurance for visas expiring up to the 30th of June this year. That's been extended to that date, where if that's the case, you can apply for this exceptional assurance. You send an email to the Home Office, give your details, and you effectively get that exceptional assurance permission that enables you to remain in the UK and indeed carry on doing what you were doing under your visa, be that work, for example, or study. There are some questions, without wanting to go into the weeds of the technicalities, about actually the legal underpinning of that status and the extent to which in all ways that will be disregarded by the Home Office in future for future applications. For example, will time on exceptional assurance always be treated as lawful residence in the UK? And if not in some circumstances, that could have a knock-on impact on future applications. I think what's the key point there? The key point would be you should only really be applying for that and using it if you absolutely have to. If you are in the situation where you can't get a flight out of the UK, you've got a COVID test that's positive, so you can't travel, you have to provide that evidence anyway when you apply for it. It should be something that you do in those circumstances, not seeking just to be able to stay in the UK, use this as a ruse to be able to do that, because potentially there could be, as yet unknown, some detrimental impact further down the line. There's also been some interesting stuff around in-country applications, so making visa applications in the UK, the extent to which you can do that and move from one visa category to another, what's called switching. Somebody who has exceptional assurance can, in the UK, whilst they're here holding that, still apply for leave in another visa category. So they could, if they've got exceptional assurance, apply, for example, for a skilled worker visa that you are sponsoring them for. And there's been a quite interesting development around switching that some of you may well be familiar with. So we've got the rules in the UK where for many visa categories, you have to apply from outside the UK. You can't apply inside the UK, even if you're here. So in some circumstances, people have to leave the UK, apply in the category to come back in. And there have been some concessions over the past year to allow people to apply in country in the UK when that wouldn't normally be the case under the rules. But there have been changes to that this year, and there was some confusion around whether you could still switch categories when in the UK if the rules would not normally permit that to be the case. And we had thought that probably wasn't permissible. But we've seen some communications from the Home Office that have said this May that you can switch in the UK, provided you meet all of the rules of the category, save for those switching rules. And that's a really significant development and clarification. So to give you an obvious example, there could be people who are in the UK who've entered as visitors to the UK. Visitors are not normally able to apply, let's say, for a work-related visa, a skilled worker visa, when in the UK. They'd have to leave and come back in. They can now stay in the UK and apply for that visa whilst they're here as a visitor. So a lot more flexibility around people being able to move into visa categories. You might think it's common sense. Surely that should be the case in the pandemic, but that has not always been clear in recent weeks. So some good news there. Just bear in mind, there are some categories that you're never allowed to apply in the UK from, for example, youth mobility visas. And where that's the case, you still can't do that. The usual rules around being able to apply in the UK full stop would still apply in that situation. A few points around the practicalities of applications. It's not been an easy time for people. You may have had, employees, prospective employees who've been trying to get appointments for visas and struggled to do so. The centres are opening up, have opened up. So the UK centres are open for appointments for people to get their biometrics taken. You can, in many cases, get a priority or super priority service to get your application sort of sped up and expedited. But you sort of have to shop around a bit sometimes to find the available appointments. There can sometimes be a little bit more delay on that. And again, overseas, the situation varies. People getting entry clearance applications through new visa applications. It does depend a little bit, obviously, on the country, the centres that are open, the appointments that are available. What's the practical point that I'm making there? Again, it's around that point on delay. The usual timeframes in terms of getting appointments and getting into the UK, it can't be assumed that that's going to be the case at the moment. There may be a bit more delay involved. You may need to be taking a view and encouraging applicants to pay extra for those priority appointments if you want them in and to start employment fairly promptly. We're still in the regime where you get a 90-day window, what they call an entry clearance vignette, to come into the UK, rather than the usual 30-day window, to account for that fact that there may be delays in travel that are outside your control, difficulty getting flights. And even if that expires, if that 90-day expires and you've not been able to travel, you can apply to get another entry clearance vignette to come into the UK. So still a bit of flexibility around that. Final point in terms of my COVID update is around a sponsor reminder, and I'm going to rattle through this very quickly because this is old hat, but I thought I'd cover it briefly. COVID-related absences from work, if somebody is a sponsored employee, don't have to be reported by the sponsor management system. And likewise, if somebody has been absent from work without pay for more than 4 weeks for personal reasons due to COVID, you don't have to end sponsorship. Normally, more than 4 weeks unpaid employment during a year would mean sponsorship would have to end. I think you have to be careful how that's used. I had a query recently saying if someone's quite keen to stay outside the country, they're enjoying working remotely, they want to stay with their partner, we're happy to agree to that, but they need to be unpaid for a bit. What do you think about that? To which I said, I'm not sure really that the concession applies in that circumstance. It needs to be for personal reasons that I think are a bit more just than convenience, perhaps something around difficulty travelling, needing to be with family for specific reasons, those sorts of things. It could be scrutinised possibly. There's still provision if you are coming in on a health and care visa, so NHS colleagues amongst us, to be able to start work once you've been sponsored, whilst you're waiting for your visa application to be approved. That's still the case, but the concession that allowed that in other circumstances, so for non-health and care roles, no longer applies. So for other roles, you can't start work pending your application being determined any longer. Delayed applications and start dates, I've touched on some of that already. There are some changes that often have to happen with start dates. We've got a system where the Home Office will exercise some discretion to tweaking and changing start dates, but it's done on a case-by-case basis, and you'd need to provide evidence in support where that's the case. You don't have to report working from home via the sponsor management system. That's not a reportable change of work location for staff who are working from home. And you can be reducing pay subject to certain limits in line with lots of the government schemes like the job retention scheme in terms of the the support that's available via that. So that's probably all I wanted to do by way of sort of quick update on some of the key COVID related immigration things. But I wonder if there's any questions, James, that we might want to pick up at this point.
Yes, is the short answer, Alex. So the same question. So I think you've answered this. The question is, we should not be checking EU settlement scheme return to work until 1st July. Is that right?
Not quite. So in terms of the 1st of July, that's a different issue in that that's when the right to work document check regime will change in respect of EU national staff. So as we've covered in some of our previous immigration updates, for the first 6 months of this year, EU staff can present a passport, an EU passport, as their right to work document for your checks. That's going to fall away from the 1st of July. We will have changes to the requirements whereby you will have to have a different document for a new joiner who's an EU national. And the most obvious way that an EU national will establish their right to work would be through the EU settlement scheme online checker. That is when that kicks in from the 1st of July onwards, yes.
Okay, so the question is, I think the other question is about the 17th May, and do they, if someone's done online settlement checks, do they still need to be followed up with a face-to-face check?
No, you don't. If you've done the online checks that were valid at the time that you did them, you don't have to do a follow-up face-to-face check.
Excellent. Okay. So you mentioned about nurses coming from a red list country can come in. We've had a helpful link to say that actually they can stay in hospital accommodation rather than government hotels. And there's NHS guidance in relation to that, which is very good. And there's a long question, which is about sponsor someone on a tier. Can you just look at this? It's in the chat. Sponsor someone on a tier 2 visa last year, haven't ended sponsorship. As Home Office said, they can apply for a replacement vignette. And the question is about whether they continue with their sponsorship duties or not. Do you want to just be reading that for now?
I can't pull up the question, sorry, so that's in the chat, is it, rather than Q&A? Okay, let's have a look.
Would you like me to do a little bit of a song and dance routine while you're reading that?
That's quite a long question, isn't it?
Do you want to come back to that?
Why don't I come back to that at the end? I'll process it. We'll see where we get time-wise. It's obviously quite a specific.
All right. So last question then on this one is, if it's post 17th May, can you still do online checks with a follow-up face-to-face on the first day? Return to work.
So from the 17th of May, the COVID concessions fall away. So we're back to business as usual. You have to do right to work checks in the same way that you've always had to do them. And there are different ways that you can do the check depending on the person's circumstances. So, for example, obviously EU nationals who've got status under the settlement scheme, you would do the check using the online status checker. People who've got a biometric residence permit, again, you can do that check online. For some people, you won't be able to because they're not eligible for an online check, and you still have to check the hard copy document. For example, someone who's a non-European national, US national, Australian national starting with you, potentially you would have to see hard copy documents showing their right to work in the UK depending on their status. So it's just business as usual, and the way in which you do the check depends on the person's particular circumstances. If you do an online check from 17th of May onwards, and that establishes someone's right to work in the UK, you don't also have to do a face-to-face check.
All right, let's crack on.
Good. Okay. I should just say, obviously, what we have done today is, because I think some of the questions are addressing what I'd term wider immigration issues, and we'll certainly be doing another immigration update in the next few weeks. We've deliberately today sort of kept this session really as a bit of a COVID immigration focus. So we've just focused on the COVID updates and changes, and are now going to look ahead really at the sort of landscape that may be influenced by COVID looking forward. So it's not a kind of comprehensive overview, obviously, of all of the issues that are live at present. So with that in mind, I wanted to touch briefly on some sort of global mobility thoughts really, and just reflecting on where we are. I think it's a really interesting time for global mobility because there are lots of different variables coming into play. We've got a new post-Brexit immigration system. That's the biggest change really for several decades, with the ending of EU free movement, a flat set of rules, EU and non-EU alike. And that has potentially good points and bad points. I think some of the good points are it's reduced some of the downward pressure on immigration numbers from outside Europe. So some of the rules around that have been relaxed. But obviously it's not so good if you're an EU national looking to recruit one. There's quite an interesting issue around, I think, what I'd term of rhetoric versus reality. So for a long time, I think there's been a bit of a separation between what the government often says and what in reality the policy agenda is, and they're quite different things. So a lot of the rhetoric potentially is perceived as being quite hostile, controlling borders, controlling immigration, whereas actually a lot of what happens, and has happened indeed, post-Brexit has been about creating a more liberal immigration system, a system where it's easier to come into the UK and work, it's easier to get sponsorship for a work visa, a skilled worker visa, than used to be the case. So, for example, the old rules around having to try and establish that you couldn't recruit a settled worker for a role before you could appoint somebody who requires sponsorship for a visa, that is no longer the case. So there's no preferential treatment requirement for British or settled workers. Obviously, we're increasingly global and internationally focused across so many sectors. And what's the impact of COVID-19 and staff demands going to be? I think that's a really interesting point. You know, to what extent are we going to have a longer term shift in the way that we work and the expectations of staff? Is our current setup, including on the immigration front, really suitable for this new way of working? People are going to be much more mobile. Remote working is going to be a lot more frequent. People are going to be abroad a lot more of the time than perhaps they used to be, particularly in some sectors like education and research, technology, with people moving around. All of those things are going to come to bear. And I think it's going to be a time where there's going to have to be some reflection, filtering into policy in a way that starts to match up to perhaps this new landscape, this new normal. And combined with that, we've got the whole Generation Y idea of people who have different expectations about the workplace, how they want to work. To get and keep good people in the UK, which is going to be a government policy aim, obviously, we need to have a system that matches up to that. Just a reminder off the back of that, in terms of when you actually need immigration permission to work in the UK, basically you need that when you are going to be coming into the UK to do work or activities. So you don't need a UK visa or immigration permission if you are based in France or the States or Australia, and that is where you are working. You don't need immigration permission to do that, even if you're employed by a UK employer. Of course, the trap that often people fall into is around people being employed and paid abroad. That's where they spend most of their time. But from time to time, they come into the UK to do some work for a few weeks, and they can get in as a visitor. If they're a non-visa national, they don't need a visa. And before you know it, they've been in the UK, they've been here several weeks, they've been doing their job in the UK for a while, they've been paid by a UK employer, and all of a sudden, technically, you're in a position where you are employing somebody who doesn't have permission to work in the UK, an illegal worker. So there are obvious traps to fall into there. So I think a key thing is, yes, if they're based abroad all of the time, fine, but have on your radar, if they are going to be coming into the UK from time to time, what do we need to do about that? Do we need to look at other visa options to make sure that we mitigate those compliance risks that can be quite serious, particularly if we are a sponsor? Do remember there is increased complexity for British nationals working in Europe. We haven't got time to go into that in great detail, but Brexit's a two-way street, as many British nationals are now realising. There is provision for visa-free travel for 90 days in a 180-day period across the Schengen countries. That's in total across those countries, 90 days in 180 across all of those countries in aggregate. But that's essentially for short-term incidental activities like attending meetings, conferences, interviews, site visits. It's not for doing work in other countries. So where that's the case, again, you need to be having visa issues in relation to those countries on your radar. And there are other issues around driving permits, healthcare insurance, if you're taking your pet abroad, making sure your visa, that your British passport's got at least 6 months left on it and is not more than 10 years old, are things that you have to be working in as a British national. And the other thing I wanted to flag is that do not forget that there are other key compliance issues as well as immigration permission that you have to bear in mind. And I'm not going to go through these in great detail because we're going to have a session further on in this series that's going to look at some of these issues in a bit more detail. But immigration is one part of the picture, and we certainly work with lots of employers recently who have had staff based abroad. They've been abroad for a while. They've gone abroad to work remotely because of COVID reasons. The employer's been perfectly happy to agree to that. And then months down the line, all of a sudden, all of these nasty issues can come out of the woodwork. They're really quite extensive, and you can get in a right pickle if you haven't worked them through. So things like, is the person employed under conditions that are compliant with local labour law requirements? Because they will have rights in the country that they're working in very often. And they can be funny things like entitlement to 14 months pay each year, or extra notice provisions, or working time issues. All sorts of things can come out of the woodwork. Depending on the role that someone is doing overseas, you can trigger liability to corporate tax in that country. That's typically if they're in a revenue generating or sales type role, but not always. It can go wider than that. Are you accounting properly for employment related taxes in that country? Do you need to set up a payroll provider? We've dealt with some nasty cases where people have been liable for taxes when they've been based abroad, and also sometimes in the UK, and dovetailing it up retrospectively is not always easy. Social security, often there are reciprocal arrangements for social security that can be entered into, but you might have to apply for certificates to do that, to make sure that when they're working abroad, you're not having to account for social security or equivalent in that country. There can be real issues with pensions if you're based abroad, even for a relatively short period, particularly if you're in some of the defined benefit public sector schemes like USS or LGPS or TPS, but also with other schemes, issues can arise. And if you're transferring data, there can be issues there. Nobody understands data protection really, apart from the data protection specialists, but I know it's complicated. And practical things like, what about insurance, your liability insurance when they're based abroad? A whole can of worms comes out. I think my top tip really would be, if you've got staff based abroad at the moment and you've not really sort of worked through what those issues are, I would be thinking, okay, who have we got? Which country are they in? How long have they been there? And what are they doing? And then work out on a kind of risk assessed basis, to what extent do we need to work through those issues, come to nice friendly people at Mills Reeve who can touch base with their international network to get advice in those countries on what you need to be doing. If you don't, you can get some nasty issues out of the woodwork further down the line.
Nice friendly people, huh?
Some of us are, James. Some of us are.
And,
but I mean, looking ahead, picking up on that theme I mentioned a moment ago, on looking ahead, I just wanted to reflect very, very briefly on the landscape that we have for employers at the moment, immigration-wise, and actually how much that has changed in recent years. When I first started doing this, a decade or so ago, we were in a much sort of narrower system for employers to operate within. If you wanted international staff to come in, you kind of had a tier 2 visa, quite, a standard work visa, which had fairly limited, constraints on it. And that was about it, some temporary worker routes as well. We've now got a much wider range of routes open to employers depending on the roles. And so really the direction of travel, despite a lot of the rhetoric from the government, has been around trying to liberalise the system in some ways, create routes that are more flexible, particularly in sort of high value sectors like academia, research, technology, and introduce more carve-outs. So we've got the new skilled worker route, replacing the old tier 2 route, much more flexible than the old tier 2 route, a lower skill level to qualify for a role, more flexibility around the salary you need to be paid to qualify for it. The global talent route, a non-sponsored route, particularly of application for technology roles, research roles, education teaching roles, where people can come in with great flexibility, be employed, be self-employed, don't be sponsored, get to settlement in the UK much more quickly, a sort of streamlined process for them. We've got a whole range of temporary worker routes now. They've been rebadged under the post-Brexit immigration system, but we've still got the youth mobility route. So people from certain countries able to come to the UK for 2 years to work, essentially in any role, like for example, nationals of Australia, and what they call the government authorised exchange route, which has routes for sort of internships, work experience, short-term research programmes. We've got a new graduate route kicking in from the 1st of July this year to enable international students to stay and work in the UK post-study for 2 years or 3 years. Depending on their level of study, you can work for any employer, doing essentially any role, or just be looking for work. So if you're an employer, you're going to be getting applications this summer onwards from students who've got that leave. They can work for you. They don't need sponsoring. That's great. Frontier workers, there's a route to enable people who are EU nationals based in the EU, who used to travel into the UK periodically to work pre-Brexit, to carry on doing so post-Brexit by getting a frontier worker permit. And we've still got that body of rules around visitors, so people to come into the UK short-term, to attend meetings, do other activities like site visits, one-off talks, some lectures, sign contracts, those kinds of things. It's got to be incidental, non-paid activities, but that route is still there and available. So a much more flexible landscape. So sometimes we can be sort of doom and gloom in terms of the immigration landscape, what employers have to be doing. But one of my observations would be very often, I don't think many employers are quite on top of what the various options are. Potentially for some roles, it's not just the skilled worker visa that's available, and to work those through and get the best route, both for you as an employer, for them as an individual, and to reduce your potential financial costs and administration and risk exposure. So continuing that trend, given that's kind of where we've come from, given lots of the rhetoric of the government doesn't match up to some of what's going on in policy terms, where might we be going? What might the impact of COVID be looking forward? And we've had a few sort of hints at this recently, including in the budget a few weeks ago that the government gave. So I thought I'd touch on some of those and then do a little bit of crystal ball gazing. The first thing is there is talk about having an unsponsored, highly skilled visa coming in at some point next year, particularly looking at a focus on sort of emerging and disruptive technology industries. Talk about that for March 2022. So I think, as well as those routes we've just touched on, potentially there will be another way for people to come in, perhaps in those technology software type roles, where people could be coming in without needing to be sponsored, with more flexibility than is the case at the moment. There's talk of a new fast track scale-up route within the points-based system for sort of fast-track scale-up businesses to enable them to get off the ground and get staff in more quickly and more flexibly than the current system allows. A really interesting one that's been talked about is the global business mobility route. So that will be a single sponsored route, which enables overseas businesses or those in the UK already to transfer staff to the UK more easily. Some of you might be familiar with the intra-company transfer route that we have at the moment. That's not particularly user-friendly, not particularly good in terms of many of the qualifying criteria. This looks to be an option to enable truly international businesses that want to move people around to be able to do so more easily than is the case at the moment. And there's talk about streamlining many of the sponsorship requirements and processes. So there's a new sponsor management system that's being trialed at the moment with some sponsors. Talk about that being rolled out in 2022. For any of us who use that system day to day, that would be great news, because we all know what a hopeless system it is and how cumbersome and lacking in sort of intuitive thinking it is. And then there's a question around, where might we be going, particularly off the back of COVID? Could we be looking at, more flexibility, particularly on a country by country basis? And I think there is possibly something out there on that. So I was listening to an interview recently with the Australian Foreign Minister, who is in the UK. There's obviously trade negotiations ongoing with Australia, and talk around, we need to have a system that allows staff, allows nationals to transfer more easily between the UK and Australia. We've had some arrangements along those sorts of lines with China and India previously. So we could be heading towards possibly a landscape where we have more country by country specific arrangements than we've got possibly at the moment. So it may be that the impact of COVID, the lack of or the move away from some very traditional ways of operating, of employing, of how staff and where they are employed and where they're based, may be one of the factors, along with those others I touched on around staff expectations and so forth, that drives a sort of acceleration of some of these changes and pushes us, accelerates us forward in terms of that new landscape, perhaps in a way that may well be happening on the employment front with things like, flexible working, for example. I'm conscious of the time and the need to pick up for any questions, so I'll stop there. But I hope that's been useful and interesting. And James, if you've got any questions, it might be good to pick up on those now.
Yeah, sure. I want to take you almost back to the start. So just a question on back to right to work. If it's a UK national passport check, it has to be face-to-face?
No, it doesn't. If it's a UK national with a British passport, the options are you do it face-to-face in hard copy with the person in front of you, or the person sends you their hard copy documents. You have those in your hand. You have the person on the screen via a Zoom call, Teams call, and you check the hard copy documents in your hand with the person on the screen. That's the other way to do it. Okay,
that answers the same one. Then does a request, so this is in the chat, does a request from a UK employee to travel abroad to see family and extend annual leave abroad by working remotely abroad for 1 or 2 weeks still incur visa and tax issues in that country, or is this such a short period of time considered very low risk?
I mean, if someone's just abroad for a small number of weeks, tagging on the back of some holiday, probably the risks are fairly low in practice, particularly around tax. The biggest issue might be social security, which is often payable day one, unless you actually end up sorting out the reciprocal arrangements that may exist between the UK and that country. In practice, is it likely to come to the surface? Is it going to be a problem? Probably not. I think you could probably reach a risk-based assessment on that.
I'd agree with that. And as long as you're still paying social security here, there is some national insurance being paid, and it's only for a short, limited period of time. You're probably going to be able to fly under the radar. The plug for next week is remote working in the UK, which will look at build on some of those points that Alex had on his cloud slide. And then the following week, and the invites for these will go out weekly, will be about looking at working in France, Germany, and the Netherlands, and picking up some of that remote working international issues where, in particular, tax is a real problem. So a lot of clients say to us, hey, can we design a remote working policy that just allows people to work anywhere? Well, yes, but there are some consequences of that. And so we'll be touching on some of that. I'm conscious of time, and we build this as being a 10:45 end. I know we haven't answered every single question, but we've answered most of them. Thank you Alex very much for a detailed look at COVID and immigration. Great stuff as ever. So I'm going to say au revoir to everybody, to stay international. Das Vidania, Auf Wiedersehen, and any other ways of saying goodbye, Alex, that you can think of? No.
Bye-bye.
Thank you, everybody. Please complete the feedback form as you leave, and we'll see you next time. Take care.